USA and from Franklin Pierce Law Center, which is one of the best institute in intellectual property law. But I am basically doing practice in IP area, patent, trademark, and till now you must have heard about what is IP, because in 1995, before that India was not having so much IP system here. So, it only started in 1995, and before that I will just explain you the historical development, how it happened. That okay. So at that time, even about common public or even myself, which are working somewhere in senior position, we never knew what is the IPR, what is intellectual property right, and what was the dispute going on there. So I will. So I will, that is why I will just start with the just fundamentals, means I will not go in very much technical detail, but I will go the whole system, how it started, what are the interlinking, how it got internationalized, and how it came into picture that we are just now reminding everything it is IPR and then patent also now. Now, patent system, what is the patent system now? The patent system gives exclusive right to the patentee of a product process to prevent third party who do not have his consent from making, patent, every time we see what is patent, we only heard that patent, if you have taken some patent, but you have a monopoly, you will not allow anybody else to do the things. But how the patent we get? We get patent because through some government order that okay, you have a right, and this right, this invention, this particular invention can be used with your permission only. You may not use it, but if somebody wants to use it, so it is with your permission. And when you will give a permission, you say give me royalty, because I have done some research, I have done something new to the public. So that is why the whole patent system started like the creation of monopolies. That if somebody, some inventor or some person has put his effort, has skill, time, money, capital, and has come out with something new and which is beneficial to the public. So they say that I have put money, I should be rewarded for that. I am giving to the public for this thing. But even if you straightway start that process or product, there is patent is only for two things, process and product. You produce a product, it is a vendible, useful to the public. Just take an example now, earlier you were having a dial type phone, then you started push button phones, then you started mobile phone, it was bigger one, then you started a smartphone. So these what are they? These are inventions, and these are something beneficial to the public. But whosoever developed this invention, so they should be given a reward, otherwise everybody will copy and nobody will do invention, because when you do an invention you put your money. And even in India they may not be very big institutions, but in agriculture you are having research, how much money they are spending, CSI how much money they are spending. Question comes there, if so much money is being spent and all the scientists they are doing their best to do something, and in lieu of that, some reward should be given for the initiative, for the work they are doing it. So that is why the patent systems had, if we give exclusivity, if you have done something very invention, you have done the invention, we will give you right that nobody can use the invention for a limited period of time, maybe for 20 years, and this 20 years after that it goes to public, anybody can copy it. But till 20 years, if it is very beneficial, people will come to you say I want to manufacture it, you can give right to them, okay, you manage and take a royalty. So this is the basic purpose, that it encourages the inventors, scientists, and basically one more thing is there, because scientists cannot be entrepreneur every time, because they are busy in inventing, so they not be expert in putting so much capital, so that they start a factory also. What they do, just like a tangible property, they sell it to others, that okay, now you produce, take a royalty for that one. So that is why this is patent gives exclusive right that to stop others for not using without their permission. but they can give this right to number of people, 10, 20, 50, how much they will, it is up to them. Now, here this is just a intellectual property, type of intellectual property, but there is a difference between this property and tangible property. Tangible property, supposing you are having house, you give it to rent to somebody, then you cannot give it to rent to somebody else, only one single user is there. But in this case, if you have a patent rights, you give it to one entrepreneur, you start producing, at the same time you have a right to give it to another person also, and you can have it done. So, that is why the difference between tangible property and intangible property is there, that simultaneously so many people can occupy it, so many people can give, and because of this there is again a chance also that people can copy it also, can steal it also, and you will never know. Somebody copies and start manufacturing, you will never know. So, this is the basic difference between tangible property, sorry. So, this is the basic difference between tangible property and intellectual property, and patent is similarly the case. People go on infringing, they take your rights and nobody will come to know. So, this is only negative right, means even if you do not produce, but only stop others producing. Now, there are very adverse view of patent system now here, and in fact, you must have in the paper you have heard that okay, somebody has taken patent for rice, somebody taken from turmeric, something like this. So, we every time used to have how they have our property is there, they have taken and now they do not allow us to use it. So, how it is like this there? Because whenever the patent rights are given, this is given by one government. If India government gives patent rights, so it is only valid in India only. It is a, if somebody gets patent in USA, so it is valid in USA only. Now, you have heard that in turmeric and rice, they patented in USA, but how it got patented? Because when they issue a patent, they say overall it should not be have a public knowledge anywhere in the world. But the Indian system was there, they are having a lot of knowledge, traditional, but they never documented it. So, even if you go for searches, you will never find. So, they particularly the one company, they produce particular type of rice, they have particular specifications, and they said okay, give us a patent, and they searched everywhere. It was not equivalent anywhere, they said okay, you take a patent. And what they did now? But they got in USA. How it affect here? Because if somebody wants to export to USA that type of rice, they will say no, give me royalty, you are using my patent. So, that is why there was huge hue and cry that Indian traditional system is there, already they knew so many things, and you are patenting outside and then you are saying no, no, it is our property now. So, that is why there was a then particularly hue and cry. There is again provision that when the patent is granted there is always all throughout 20 years there is a priority, if you bring out something that it was already known in the public, you can get it revoked also. So, then some application went there, they filed okay revocation that this is already known here. So, the patent was revoked there. So, question now here comes only because first of all thing is there, whatever your knowledge, whatever the invention is there, you should document it. This is the basic requirement, and then CSIR did the thing, all the knowledge, traditional knowledge which they are having, the benefits of turmeric, benefits of this thing, all jadi booties, this thing. Now, what they have done? They have written the document, prepared all the document, searchable document. Now, they have given to help to European Patent Office, they have put their database in their data. So, now if you search anything you will find, so nobody can get a patent now. So, here it is a adverse view of system that patent create monopoly, monopoly kill competition, killing company hampers economic growth, therefore, patent should not be granted. This particularly a opinion, one part of opinion there. And during my discussion, if you have any question about patent system or anything, it comes to your mind, you may tell me. I will like to, because it is not what I give you. I want you should take whatever you want, not whatever I want to give you. So, you ask any question in between if you want to get any clear, you have any doubt about patent system, so you can even raise the hand and ask me any question. So, I will first give reply to your question, only after that I will go further, because my purpose is there at least you should know a little bit how patent system works and what is the basic issues are there, why it is beneficial to society or not, and if supposing you are a scientist, you are giving invention and how you should protect your invention also. So, I will give overall, but later on you will be getting all the lectures on specific systems also. So, this is the adverse system, because okay. Now, there is sporting system also. What is sporting system? A monopoly is something in public domain that government takes from public and gives to specific person. But invention is something that did not exist before and was not in public domain. Therefore, patent system enriches public domain with the knowledge of invention. So, very simple, because something is not there already. Supposing there one drug is there, cancer drug was not there, you have done a research. Now, you say I have done a research, I have spent millions of dollars there, rupees also. Now, you have bring the product there and now your product is known. Everybody say now I will manufacture. So, where you go? So, that is why I say it was not in public domain, it was a knowledge, public knowledge was not there, but inventor has done something extraordinary and brought the knowledge and has developed something which is beneficial to the public. So, that is why they say it enriches the public domain, it enriches your knowledge. Then as for patent, patent is personal property like any other tangible and is creative inventor by investing his skill, knowledge, capital, labor and other resources. So, whosoever just I gave an example that this institute is there, they are having research, so many people have done a research and they have put their money, time, labor, capital, everything they have put in there and they have come out something very tangible which is beneficial to society. So, why not society should give it to? So, this is why, because if you do not get any benefit out that, but why will you research? Who will motivate you? So, that is why a system is there, it only gives you a patent does not any positive rights. No, I explained to you already, there are some bundle of rights, right to make, right to use, right to sell, offer for sell. But if supposing you have done a research which is not beneficial to the public, and no entrepreneur is coming to invent this thing, your patent remains, but what happens that one? You do not get any royalty, because it is a negative right. If somebody wants to manufacture, only then he will give you royalty, but if it is not so much beneficial to the society, so then nobody will come. So, that is why what you are being paid of your skill, your research, your invention is only the benefit to the society, that is why. So, only benefit to society is paying in lieu of that one. So, that is why commercialization aspect of all intellectual property or patent is very important. Any question you can ask in between, any question if you want, because these are some of the very basic things you may be getting in papers daily. We are posing this thing, why they, so when I will start coming for international, then how I will come to discuss what. Yes.
What is the benefit share mechanism? Suppose I file a patent and I got so I am in government job. So what is the benefit sharing mechanism? How much percent goes to
that depends the government to government. What happens now? This is your employment contracts. What happens if you are in government, your job is secured, they are paying you the money, you are doing some research, but there may be some getting job is getting, but you do not do anything, still you will get a job. But there are some person who are having very initiative, very, and they come out with something very new and they get a patent. Now, this as a matter of right, first right goes to the inventor, but in case of an inventor has assigned his right, I say you can sell it, assigned to the corporation, they will get. Now, the company, your organization has to make your own policies that if somebody is doing something extra and creating some intellectual property or invention he is getting, So, if commercialization is there, definitely we will give share to. So, this is the nothing to do with the patent, nothing to do with invention, it is the internal policy of the company. This is just like we are minimum guarantee we are giving you, that we are giving you job salary. But if you do something extra by which commercialization there the company gets money, they say we can have a sharing with you. This depends company to company. Some universities do, like they say if you commercialize it, we give you 20% of royalty. Some say we will give 10%, and that is depend on company to company. So, okay. So, the patent right of property restricted in terms of scope and duration cannot be considered as a monopoly, because it is for a limited period of time, it is not permanently. After that, all the knowledge which the inventor has done, so it goes to public, it is free for all. I was giving one lecture somewhere, I was just discussing about some food patents. So, one was sitting, oh, they have taken all the patents, foreign people have taken all the food patents. So, what we will do it? So, they will not allow us to manufacture, they will not allow us to make these things. No, this is not like this. This is open to you. If they have taken patent in USA or not here, so you are free to copy that one, because the system is there, knowledge is there, they have published it. Whatever the patent whatever the application you file, you publish in the patent office journal, and even if anywhere you file, it is within 18 months it is published. So, you go for searches, you find whatever you require, you immediately take it, copy it, and if it is something patent is there and it is valid patent, then royalty is there, but 80% patent you get free. So, what you get, all of the databases, all the invention, you get all is free. I will again come to what is the benefit of this particular system. The patent is now patent right leaves many not only beneficial ordinary public, prior art. Now, what happens if you are doing a research, you are a researcher and you want to start from where to start, what topic I should go. So, this is the database, because whenever you file an application for patent, this patent application is published with full specifications in the Gazette. Patent Office Gazette there, but even then European patent, I will cover European Patent Office also. So, this on single click you can get all the databases, you only have to see keywords, and in fact, you can design your research, further research what should you do. You get a foundation, base foundation. Earlier what happened? There was no centralized databases, no patent system was there was no publications like this, particularly in India there was no publication. People used to go all the research, and in the end when they go for a patent, they said no, you can't get a patent because already this type of research has been done. So, it avoids a duplication of research also. So, particularly it is very good for researchers, there are so many databases. Immediately, just like in Google, if you want anything, you immediately click and immediately a reply comes to you. Similarly, in case of research also, everything you are doing a research, you can get a database, what is the present state of art, it is called a prior art. What is the present state of art, on the base you can research strategy you can define. I will just go for this one. Patent inside company as the lead to many improvement patent as competitors are motivated to design. Now, if you have done a good product, it comes in the market. Suppose take an example, a telephone system comes, now you say it is very good. Now, the competitors what they do? They say now because we have to remain in competition, so we have to do something extra over and above this thing. So, they have to improve the technologies. So, there is always a combination of improving the technologies. So, in that case what is happening? They will come out with a new phone, with the new features, continue. So, it is a very continuous process. So, what happened? The patent system, because they know you have developed this thing, it is open to public, they have published already what is the specification. Now, you are designing around, it is called a designing around. You know your platform of research is raised and you further and further research. So, in further and further research what you do? You immediately give benefit, more benefit to the public. So, it is very advantageous to, and now what is the benefit to public? Now, basically whole patent system is made only because it should benefit to the public, and there is always an apprehension that, take an example of drugs. They say they have done a research, we are selling a drug for 10 rupees, and outside they come with a new drug and they charge a little improvement is there, in 10 rupees they charge 10,000, and they have been a case. But there are safeguards in patent system itself also. But only question comes only there that whether public has been benefited or not. If new drug comes, supposing that side effects are less or therapeutic efficiency is more, so public is benefited. So, first of all you see what is the patent system is only first question comes, is it benefit to public? If it is benefit to public, then what should be given to the inventor? Can we make it very expensive that public cannot afford it? Can we make it very cheap? So, there are some safeguards, supposing how to make the product cheap, because when the rights have been given to patentee, the inventor you have, then it is their right how much they, but supposing public is not able to afford, so nobody will take it, product will not sell. So, they have to make a balance, but government also has some, because some of the inventions are so blockbuster inventions. You can say once in lifetime these type of comes. So, in that case there is some compulsory licensing system is there that public should be. So, everywhere the benefit to public judged. It is not like you monopoly and you say you leave it, nobody, I will not allow anybody. If you do not manufacture, you can get a compulsory license. If you do not allow to manufacture, you do not give a license to other, they can revoke your patent also. So, there are safeguards in that one. So, it is not like that absolutely it is monopoly like this is there. There are other provisions also, government can use at less royalty, they can fix the royalties. So, there are different ways. Commercial reward for converting inventive ideas into vendible useful product. Earlier if you say, if you look back 20 years ago, 25 years ago, in universities so many research was being done. So, it was being judged, okay, how many articles you have published. They use the research, publish the article, use the research, publish the article. Now, later on the concept came, you are doing a research, it is academic research only. Is it beneficial to public? So, why not focus on beneficial to public research? So, that is why the concept has changed a lot now. When the research comes now, you first of all the question comes, we give you project, government say we will give you money for funding the project, but do research something which is beneficial to the public. So, one factor has come from academic, you have come beneficial to the public. So, your focus of invention, focus of research has also changed now. So, it is a focus on, so commercial reward for converting inventive ideas. So, we have in India they are a good human resource manpower, they can do research also, they have very fertile mind, but only question is there, at the time when the fertile mind is there, they have to survive themselves also. So, they want a minimum guarantee that okay, if you do the research, we spend our time, we spend money, we should be given the basic necessities of life, and that is why the various research institutions are coming, and they say we will give the job, minimum guarantee we give you that you will, and till retirement will survive, you can survive very well, but if you do something extra, we will give you extra also. So, this is why you are having inventive ideas. You may be academic, you may be publishing an article and nobody is reading, or if somebody is reading, they are writing further article, they are writing it. But the focus now has been changed to vendible products, useful to the public. So, that is why whenever you do any research particularly, they say focus on the provide invest capital to develop new products. So, it gives an immense incentive. Supposing you have come out with good idea, you convert it into vendible product, the market is selling, you are getting royalty. So, you get motivated, oh, I have done something very, you will tell your friends also, yes, I have done the research, I have got the patent and I have commercialized it, I am getting a royalty also. So, what you will do? After that, you will be motivated to do further research. So, it will start a platform, it will start a chain reaction that okay, your level of will go rising and rising, and you will feel yourself that okay, with flow of time I have got so many patents, I am getting more and more and more. So, it is incentive to you, to scientists. So, that is why, and it is benefit to the public also, but drawbacks also there I gave, because it is creates a monopoly. Now, because how it started, why it started, generally patent system, why, how it created in the mind. Now, if we look back the year of 1856 or before that year, and particularly in the Indian system, Indian system, but they say whatever knowledge you are having, it should be used for the benefit of the public. There was no concept of selling your this knowledge. You say it is free. If you are having a knowledge, you will say it free. So many Upanishads, Vedas are there, everything is full of knowledge, but even then there was no system that okay, there is restriction on somebody and using it in knowledge and asking for money. So, this look when the patent system came, but giving this, people said no, we have don't, our culture is not like that. If we have knowledge, Guru Shishya, we should impart knowledge, how much you can give, and you can impart to so many persons. Knowledge never take decision. Intellectual property similarly, it by sharing it increases. Supposing I am just discussing with you, I am getting your questions also. So, it is not I am not giving a knowledge to you, maybe so many you are getting a knowledge, but I am also getting, it is sharing and it is multiplying. What I speak you, it does not decrease my knowledge, but it increases the knowledge of all of you. So, that is why intellectual property in our culture it was there that okay, knowledge given free, you as much as you can give to society, give it free to them. But the patent system said no, you have to get a royalty for doing benefit thing. So, it was a little bit against our traditions. Now, that is why I come back to 1856. At that time the British rule was there and development was not there, there was no industrialization. So, there was one, if any country or any society want to grow, they have to go for industrialization, they have to go, the human resource is there. If you put your human resource in some value addition in some products, so its value increases. So, they say if you want to increase of anything, any vendible product or this thing, you first of all put your human resource skills in that one. Take an example, you are having iron scrap, it is iron, machine is there, iron is there, and you create a factory, human work on this thing, they make a design this thing, and they come out with a car. The product, supposing car, scrap value of car may be 100 rupees, 200 rupees, but it is selling 3 lakh rupees. How the difference between these is there? That 200 of material put there is now selling for 3 lakh rupees. What is the difference between the two? Because human intellect has put their skills in that one. This is a value addition to that one. So, this is the intellectual property which has been put into that is why its value has gone. And by this who gets riches? Society gets riches, the inventor gets riches because they will get a job, factory comes out. If factory comes out, so many infrastructure comes out, people get job, people start township. So, it is a multiplying effect. So, what is happening now? Value addition is very important. So, in that say primitive time, there was not much development, technical development, even salt making was traditional one there, people are not making also. So, in 56 what they had, that the crown, they said whosoever expropriates to inventors to new manufacture for a period of 40 years. If you are developing something very new, then for 14 years you will get monopoly rights. It was in 1856 started. Then later on they said it is not only manufacture, they say exclusive privilege for making, selling and using invention in India. Now, at that time it was not only inventors, because earlier if you see the patent history at that time, because there was no global communication, transport system was not very good. So, people used to go, if you see the the traders used to go to other countries for 3 months, 4 years, 5 years, then they used to come back. Fayan, they have Columbus, they have all traveled by sea. They say even if you go abroad somewhere, and going abroad also has a very good effort, and if you think something new technologies, so they said you can also have a monopoly on that one. Early system, the basic purpose there, that okay, whatever you are bringing for the benefit of the public, so it should. But at that time there was one more problem was there, because people who were influential and were close to the crown, they started bringing new and new things, whatever things are new, maybe old things also, and they started getting monopoly. So, what happened, those things, even a process of making a salt was patented, and the price of salt from 10 rupees to state went to 100 rupees. So, then there was rentment also. So, this type of monopoly still you sometime you are not able to judge whether it is a new thing or old thing, and still you try to drive from the benefit from the society. So, this was at that time particularly because the industrialization was a must, and even bringing it, then people said why bring technology from outside, we start our own. So, people started doing research, whatever how they started, if public demands something, there was some demand, they used to research something and bring us a new product. So, in that case it was. So, 1872 then, because till date it was only process was there, they say okay, if you like the crown, they will say okay, now produce this one. But later on the requirement came that whatever invention you have to explain what is there and complete specification there, and you have to show that it is something new which is not in public, and then you can get a monopoly rights. And these changes, because there are some monopolies going which are also affecting the public, that I take the prices were going high, there were incremental inventions which are not even than the price. So, there was a public apathy also, public cry also. So, that is why laws went on amending also. So, I am not going much detail, but basically the system how it started, it is only started inventions, technical process, technical knowledge, if you bring for the benefit of society, so you will get a monopoly right. So, purpose was this thing. So, basically in 1850, because earlier UK was the main who started this thing, then later on statute of monopolies came, that was the first codified act, and Indian Act, because they in British whatever they used to amend, they used to apply here, they were amending that. So, in 1911 the Indian Patent Design Act was there, it continued for very long year. So, in 1911 not only patent, there were design also. Patent is for utility, active functional things are there, design is looks to the eye. So, there was only one act, even our patent office still in the beginning it was only both patent and design was looking after now. So, patent design, this 1911 act is a combined act, and it continued even after independence. After independence, now country became independence, and our country was not industrialized at all. Even a small pin was to be imported coming from UK or developed countries there. So, government of India now they said now we have to develop our society, and whatever have to make in India. In fact, if you see, even the Prime Minister still talking of make in India. Why talking make of? Because when you talk of make in India, you bring industrializations. Industrialization means your human resource is very rich in India, but they do in a scrap or they add value addition, come out with a good product. So, this value which increases, this upgrades the society. Not only it generates employment, it supposing somebody gets a job, he spends the money, this money spent is income for somebody else, then they spend the money, this income for somebody else. So, that way it is a spiral effect is there. So, that is why make in India it was the basic purpose that everything should be made in India, so that our resources, our human resources can have an value addition in that one, and they get enriched by that one. So, we started manufacturing. So, our policy was there to manufacture. So, they said we have to now develop our patent law in such a way that it is suitable to our society, that it should encourage new invention, produce new vendible product or produce new product straightway, have a new technologies, so that we can pursue each and everything. So, in that case, if you recall earlier, there was only two type of cars were there, Ambassador and Fiat. Scooter was there, the waiting time was 15 years. In fact, particularly at my age, when I was a student there was no industry in villages there. And even when I was in BSc there, I used to, we purchased a bicycle, it was a very big thing that we have purchased a bicycle, because no other transport was available. Scooter was only sometime it was coming on foreign exchange, otherwise waiting time was 15 years. Even 1986, I came to Delhi in 1986 after when I was transferred here, the waiting time of getting a telephone was 15 years. You can very well imagine that whatever small technologies were there, but demand was very high. So, that is why the focus was there that our patent system should bring the industrialization, only then the society can rise. So, that is why they started an anger committee, they said give us a report what should be there. So, anger committee, on the basis of that the act of 1972 came. It came in 1970 because rule making it takes time. So, up to 20th April 1972 it was enacted now. In this basically purpose was there कि whosoever be getting a patent, they should manufacture in India also, and because they wanted industrialization, our purpose was to industrialize it, produce as much as you can. This, and at that time there was foreigners and drugs, they were not included in the patent. They said no, our health system people cannot afford it there. So, instead we will not allow drugs to be patented there. Product patent was not there in that, but if you can produce by, you can find a process by which you can, process can be patented, not the product itself. So, what happens after 1972 to 1995, our system continued. Then in 1995, and I will discuss again, before that, because our country could not produce so much technology so that you can import from other, because for importing you require a foreign exchange, because whatever product you are not manufacturing in India, so you have to import from others and you have to pay in foreign exchange. How to get the foreign exchange? You get a foreign exchange only if you export something outside India, and then there is a competitive market outside, if you are exporting something to USA, so many other countries also exporting. So, what happened at that time, in international trade there was various product which India could manufacture and export to other countries. India was very good in cotton market, clothes they used to sell, because labor was cheap here, so they wanted to sell. Similarly, in Brazil there was coffee was very cheap, they can get it. So, they try to interlevel the international trade. So, in that case in 1947, 1950, various 23 countries said, okay, let us sit together and we make in some agreement. So, they started a GATT, international trade, general system on tariff and trades. They were only fixing that. One more thing is there, if supposing I am manufacturing something here, take an example that we have manufacturing cars here, only 2 cars were there. If somebody brings cheaper car outside, so this industry dies. So, this is called protection to the industry. So, this protection to the industry was also very important, otherwise whatever outsider will come and sell the market, or will, and our industry will die. Take an example on FDI. What is happening in FDI? We say if we bring the big stores, they will have economies of scale, they will produce cheaper in large scale, they will open their own factory also, will produce the material, they sell the cheaper there. But what happened to our small traders? Where they will go? So, this social impact has to be seen for everything. Similarly, in case of patent also, in case of exporting and importing also, they said we will not allow outsiders to come and manufacture here, because it will kill our industry. So, where our people will go. So, that is why our was a protected market. It is called a, but we have closed market. We will not allowing others to come. But how you are stopping them? We can stop by two ways. One is called tariff barrier, one is called non-tariff barrier. So, tariff barrier means put heavy custom duty. Non-tariff means to ban the item, you cannot bring it here. So, general agreement trade and tariff was there, that they used to seek what the duties you can impose, so that cheaper product can come here, at the same time it should not kill the industry here. So, this continued, 23 countries were there, they continued. In 1976, when the agreement was going on, it was only in goods, how to interlevel the goods across the country. The developing country was there, they said instead of only goods, we should add, this is the international trade word, and we should add intellectual property rights also. And a country like India, which were only struggling in goods, immediately an idea came, what is intellectual property right? Intellectual property was there, India was opposing, because until date, whatever the technologies may be the outside, they were copying it, particularly in drugs. What are the drugs used to be outside? They were just noting there what is the formula there, generic drug, no research. They start generic drugs and they were very cheaper. And even in India today, 60% of generic drugs are being supplied by India. India is called the pharmacy of the world. Now, if we say we have to give patent, so where the generic industry will go? So, we are opposed to that one also. So, under this background, developed country which were doing research, they have having very big research organization. If you see Bell Laboratories, all corporates are having their research wings, and they had huge employment where the only R&D was there. But in India, the various organizations, they were not having a big R&D wing only. They were only operation, start, produce, that is all. So, not only India, all other developing country was opposing that, okay, we should not include intellectual property rights in the GATT agreement there. But the question comes only there, who is more powerful? These technological developed countries, America, European Union, Germany, Japan, they were on one side, 8 or 9 countries, and 100 countries on other side, they were underdeveloped countries. But because if we wanted something advanced technology or for benefit of society, we were importing from others, and importing means we have to export something, our thing, so that we can also, otherwise how will get the dollar money. So, that is why all this country, they are more dependent on the technologies from outside countries. And they wanted that these technologies should come here, so that our people should get benefit of those technology and also learn more, learn those technology, do further research and also. So, development of society. So, there was a balance to be made what to do in this case, that whether you become or not. If you want to become, they said no, if you do not become a member, we will not allow anything to export in our country. You also allow us to export our products there. So, it is a two-way system. It is remove those barriers, tariff barrier, non-tariff, remove those barriers, make an international trade, make it a barrierless globe. But automatically the objective of technology in the developed country was there to have access to the market, so that people are there, you can sell their product in our market, because our is more populated market there. And our motive was there that we want your technologies, But if we allow you to come here and sell there, where our industry will go? Where our people will go? From where they will earn? So, now their balance had to be made, and lot of discussions when from 1986, sorry, it was 1986 to 1995. Ultimately, maybe some pressure, whatever be there, the balance has to made, and it was balanced was made like this, that we said, okay, we become member of WTO. They started, instead of GATT, started a international trade organization, that is called a multi-trade organization. It was named as World Trade Organization. It started on 1/1/95, and out of 1/1/95, they said in this they include, it is not only goods which are important, the services which you give, that is also important, banking service, education services. So, they said this is also a, just like a goods, you can also trade in services also. And even if you see now, earlier for education, everybody used to go to America or UK, you study there, because their education, their services were there. Now, India is also coming up. People are from developing countries, definitely are coming. We are much better than those. So, our pace of development has come up. Why? Because we started competing with them. We started not only copying, we started learning from technologies how we can bring, but still it is, the things are not so easy that okay, overnight you can get, it takes time. So, then India signed agreement and also signed one agreement, that is because becoming a member of the WTO World Trade Organization, there was some minimum set conditions that okay, you will have a mutual agreement stateway like this, that you want to export in our country, but allow us all to import in your country. So, there was a, just like they said, remove all tariff non-tariff barriers, bring custom duty to nil with some conditions that you should protect your industry also. There was some duties also there, that safeguard duty was there, that immediately you can't overnight change. So, our industry is ready not to take to competition. So, that okay, in that case they said you can put safeguard duties. Similarly, some outsider, they are selling in their country amount of a product of 10 rupees, they want to kill our industry. They say we will sell here in 8 rupees. If Chinese is happening. So, in this in that agreement it was there that we should put some type of duty that was called the anti-dumping duties. You have heard sometime steel, America did like this, and in China also they are putting so much material here, and if the investigation being made there, they are selling costly product there, but in India they are selling at a lesser rate. So, purpose, kill the industry here, create the monopolies, that our industry dies, so they become a monopoly, then rate increase the rate. So, these are tactics were there, but this WTO agreement took care of this thing. As a part of WTO agreement, they said intellectual property right also should be there, that whatever technology the developing country bring to this country, it should not be copied straightway. They say we come with a product, open our factory, and somebody again comes, they copy our product and they also start a factory. So, where our competition go? So, we will not bring like this. So, that is why it was a mutual agreement, okay, you also grow, we also grow. So, that is why TRIPS agreement was signed. They say then after signing what to do now? Signing means they say you change your laws. TRIPS agreement made some conditions. Okay, you will have your laws, minimum set of conditions were there. So, these conditions will be fulfilled. You will amend your laws to fulfill those conditions. So, that is why those conditions, all the member countries, near about 143, 145 agreement members are country, almost whole of the world is right now. So, they said this whole world have some minimum standards. So, even our patent law or others patent law, 80% is almost same as per the standards of this thing. 20% flexibility is being given to take care of your society, because technological development have different requirement. Our country have different requirement, least developed country where there is no manufacturing like in African countries, they have different development, different. So, they can 20% flexibility there. So, in this keeping in view all these things, from 1195, India was given 10 years of time, that by 11/2005, you amend all your intellectual property laws. What is an intellectual property laws? Patent, trademark, design, Plant Variety Act, and copyright. So, the 8 laws are there. So, you amend your laws and bring it compatible with the TRIPS standards. Just take an example, earlier the term of patent was 14 years. Now, they say all country will have 20 years. So, they have to amend that one. India was not having a product patent for the drugs, medical. So, they said you have to have, because as per agreement, I will just have a few ideas of, because I am, because when I come further. So, basically slides are little bit a general knowledge about these things. So, that is why I am giving this one, because all these TRIPS agreement in your syllabus you are already having what is in detail there, but I am giving you background, you can understand why this started like this. That is I am not touching much substantive part, but because if you have know the background, you can understand what is the rationale of going for patent system or intellectual property right. So, in 1999, the act was amended, because started from 1/1/2005. Now, in patent there is a once everything is time bound. If you have filed a patent somewhere else, so in India it becomes in public domain, you can't file it here. Why to file it? Because it is already public domain, already published there. So, they to protect that, and at that time there was no product patent there. They say what are the medicine product patent have been taken by outside countries, they will continue for 20 years. Supposing somebody took in 1994, so it will continue for 2014. Say what to take care of in 1995 when you have a, so those will, you will not get a patent of those things. So, they said transition period, they said instead of, and we were allowed 10 years time. So, 1/1/2005 we had to amend our law that product patent for medical drugs were there. So, during 10 period, those drugs which are patented outside, they could have been patented here, but you will not allow. So, they say in the intervening period, if some patent has been granted there, you can get exclusive marketing rights here. Though we do not have a patent system, we have a 10 years time till 2000. So, in 1999, an act was amended and a chapter was added for exclusive marketing rights. Means, if you are having a patent outside, product patent, because here India is not allowed, you can file an application here also, but you will not be getting a patent, but you will be getting a exclusive marketing right during period till your patent is considered and law is amended, you can only sell those products there, exclusive marketing rights. But even then our exclusive system was so cumbersome there. So, only I think, and you must have heard the Gliva case or Novartis case, they were considered for exclusive marketing rights there, but when the patent regime came there, their patent was rejected. So, automatically when the patent rejected, the exclusive right also goes there. So, only this was the main. So, that is why now in background in 99 the Patent Act was amended to add exclusive marketing rights. And you know, this act was amended from retrospective date from 1/1/1995, just to take care that those drugs, particularly patented drugs which are given patent outside, because it was not allowed, they should be protected that from back date. They can apply for exclusive marketing right till we our amend act in 1/1/2005. So, for 10 years you can go for exclusive marketing. It is just like a patent, you know, patent what is it? It is exclusive. So, see. Then, so in 1999 act it add exclusive retrospective date from 1/1/95. Then in 2002, then the major amendments came here. They said in that case, they made the term from 14 year, earlier it made it 20 years. And in 2003 also, they said when the patent is to give for all field of technology, they added computer programs also, that if it is a computer program were protected under copyright. They say if it is a pure computer program, it will be protected under copyright, but it is having some application, just like now you take a mobile phone. What is this? Mobile phone 5 years ago must be same, this same, but their features are different. Earlier you could not receive email, now you can receive email. Earlier you cannot receive MMS, now you can receive MMS. Earlier you could not receive. So, these are new technologies coming in the same product, but it is coming, it is because of softwares. You have to, so they say we will in 2003 when the amendment came, they said computer program, if they give some technical contribution, give some inventable new product, so they can be protected there. But pure computer program were protected only under copyrights there. Similarly, there was term of patent was there. So, I am not going to discuss final in effective 1st January 2005, this is the last amendment came, because 10-year periods was going up. 1/1/1995, India was given 10 years time to amend their all the laws. I am focusing on patent, Civil Trademark Act, it was Trademark Act 1958 was there. They developed new act, Trademark Act 1999. So, in not only goods, services also are added there. Earlier, the services were not protected. So, I am not going to discuss those particularly, focusing on patents only. So, in 2005, what happened? This is the final patent act which is amended. In this, they said now we can give you product patent also. So, basically because I am not going to discuss the substantive portion of patent act here also, because it will be taken by somebody else there. So, you will get my, but this is the total history in this one and what is the rationale why it got amended. So, now our patent act is compatible with the TRIPS agreement, but there are still some controversies in section 3D or this thing, that what is not patentable, incremental innovation not patentable, but even then I am not going to discuss. Substantive part I am not going, I am going to discuss the impact of that one. Any question?
So, you mentioned about substantive.
Substantive means how to test whether invention or not.
No. Just in law there are two laws, substantive law and procedural law. What, how we can
No,
differentiate?
I am procedural means parliament. Parliament what done? Parliament makes a law. They said this is a substantive law. Okay, you can get a product patent or not patent, you can get, but now how to implement this law?
This is a procedural.
So, you what there in this act itself, they said every time you cannot go to parliament, they give a power to the executive, the minister, that okay, for implementing this act, you make rules. That is why you say in 1999 Amendment Act came, in 2000, you see starting from 90, Act passed in 1970. 1970 Act passed, but it was implemented 1972, because in the intervening period they were making rules that how to, what are forms to be made, how you will implement this thing, how you will apply procedure. So, these are the rules. This is called the delegated legislation. So, it has force of law, but you cannot go beyond what is written in the act itself. If something goes beyond that one, it will be unconstitutional.
Sir, one thing I want to know. There is a you mentioned about utility patent. Still, although it is not allowed in Indian Patent Act, can you make some differences?
Sure.
Utility patent
Yes, I will. What I will do. Now, this patent law, when it came here, because we India basically we are against the protection all the time, because we wanted whatever we want to sell, let us sell there, but if somebody want to sell there, we can't get them a patent, that we give them patent to them and they will stop our industry there. So, we had a fear, because no, we were not technologically so much advanced, and technology they were advanced. Now, if those people get a patent here, so they will not allow us to. So, our main focus area was on drugs mainly basically, because India was. So, this patent system here, when you get a patent, you have a very strict procedure for granting a patent, that novelty should be there, inventive step should be there, utility should be there, and the searching is worldwide, for databases are there. So, I will just come quickly, still I will go a little bit more fast in fact. So, what happened in that case? So, we were focusing on this one. Utility patent, this is called utility patent. Then a utility model patent. That is in fact we were generally said incremental inventions we will not allow, just like section 3. If something is there very specific new things have given, we will give, but otherwise we will not give a patent. If supposing you create something small invention over and above, just taking you an example, this pen is there. Before that fountain pen was there. Now, in fountain pen has some defect, they started ballpoint pen. So, this was a new invention particularly because fountain pen has some drawbacks, and this then ballpoint pen came. So, we generally were saying something very different should be there than the. So, this novelty was there, it was agreed. But even then if you say okay, I change the cap, instead of push button I say screwdriver, threading is there. So, we say we incremental we will not give. So, because what happens, you go and design in different things, but something very where you novel is there, but something it should be extraordinary also. Inventive stuff means normal, not obvious to a person, means unless you do some extra research, you cannot reach that one, because you have a lot of state of art, you have so many technology, you can search everything, but you can't do combine here and combine here, make it like this. So, that is why I say we said. Now, utility model is there, that is called for incremental only, that is without going for novelty check or this thing. They say because this is a very long process, and it is blockbuster things may be coming, you open it, but sometimes you create very, very small things also. Take an example, I give an example. In time of Diwali, you put ladis in this one. So, earlier there was a very difficulty that how to put a cable like this, one cable is there. So, you have to take a full laddi, should be very lengthy, and then you put in there. Now, say it is very difficult, they say we have 10 laddis straightway. So, they said we created an extension cord like this, and everywhere in the between you can take a connection from there, in parallel was there. So, these are very incremental inventions, but it facilitated. So, these small incremental invention, particularly which you can say, you can just say. So, they say we can give it monopoly for this for a very small limited time, maybe for 5 years. But India is not still having this one. India is thinking of this thing. In fact, this utility model patent is more useful to India, because our inventive people who are working on the small scale industry, they are more interested. We have some small changes we have brought, and we should give a registration for that one. But it is in the offing. That is, this patent system is for big research organizations, but utility model is incremental. So, in fact, you want to see, you can see the paper, and DIP site is there. They have prepared a paper in 55 countries, utility model is there. India is not there, but they have given all the data, paper is there. You can see on the site of Department of Industry Policy and Promotion. They have made a paper and invited comments also. Any other question? Because this particularly I have just given you the background, and now I have discussed so many things about him. Now, why patent now? When we sign the TRIPS agreement, 80% of our law is compatible with all over their common laws. So, 20% is different, which is suiting to our society. How it started, I am giving just background. formation of World Trade Organization. You know, I just gave, because before that, for international trade, there was negotiation only between the tariffs. General agreement tariff did so many countries, so that there is one abundance of item, they should supply here at a cheaper rate. Similarly, we can, so that you should not in such a way that the local industry should not die. If there is threat to local industry, we used to put custom duty on that one, and the custom duty was to the range of 200%, 300%. But when the WTO agreement signed, they say there should be no tariff barrier. Tariff barrier only in few cases. You have to make the whole globe, if abundance of one article is there and market is there, you supply so that public can get a cheaper rate. Don't put any barrier. But each country has to take his, what is the share? Supposing outside country comes and sell cheap here, it is good for the public. But if it is, it kills our industry, so how it is beneficial to me? They earn the profit and take away. So we have to make a balance. That is why the tariff, non-tariff are. So in 1/1/2000, they agreed for a multi-trade organization, which was not only goods. They will say we will discuss about the intellectual property rights also. This is also tangible property, just like goods is a tangible property, intellectual property is an intangible property. We have to protect that. So that is why these TRIPS agreement are there. So 1/1/95, that multi-trade organization was called a World Trade Organization. TRIPS agreement was only related to only intellectual property rights, patent, trademark. Then there is a Paris Convention. You know, this intellectual property rights were, India was not a member, but earlier countries, European countries, in 1873, they combined together. They said in Paris Convention that whatever the technology we develop in any country, member countries, we should give benefit to others also. So what they said in Paris Convention, they have two particular important. But India became member of Paris Convention after they became member of it. They became on December 7, 1998. I will just say what is the Paris Convention, what benefit for of the Paris Convention, I quickly give him. Then similarly, because till date our patent system was only filing of India, within India, that is all. They say if somebody wants to file from outside, you want to file India, what to do? And not only because reciprocity should be there, because when you agree, entered a TRIPS agreement, any benefit given to other country should be given to benefit of India also. So how Indians will file outside? It is just like in WTO, this was there, this was a globe, make Indians or everybody a global citizen. If my country gives some benefit to my citizen, then you have to give all other citizens of member country the same benefits there, irrespective of. That is why when you want to apply for a patent, they cannot ask that whether you are Indian citizen or they ask Indian citizen, but they are no different benefit than USA citizen or Indian citizen. This is a global, everybody can apply for a patent whether outside. But only question then comes, you have, there is, when you apply in a particular date, you get a, your technology is checked on that date only for novelty. Now you are filing in USA, but same day to filing in India is very difficult. How to protect yourself? The Paris Convention said, all the members of Paris Convention, what they, you file in your own country, patent application there, your invention, within 12 months you can file here also. So your technology will be processed as if you have filed 12 months ago. So that is what it means, very easy. I file here, then file it. Then say how to file it. But I am sitting in USA, because patent right, if I want to get in protection in India, India has to give, Indian patent office to give the right to me. How to file it? Then they said, they had a patent cooperation treaty, the member countries there. They said you can do one thing, you file your own country, within 12 months you file in central place, that is called the international application with the WIPO, that is the International Bureau, and it means as if it has been filed all member countries. So, what happens now? If somebody has got an invention, so ye file first of all their own country, within 12 months they can file an international application if they want to go for patent cooperation treaty, or within 12 months if they do not want to go all the countries, they can file in one country under Paris Agreement within 12 months. So, within 12 months you have to take an action, ki which country you want to file. So, you get a window of 12 months. Similarly, others also get the same thing. What I am getting in India, others will get the same thing. So, this patent cooperation treaty is a filing system and it is administered by WIPO. Its created is International Bureau. Okay, understand now? This PCT also, I think I have seen it is there. What is the procedure of filing in PCT also? But only it is internationalizing you, and at the same time others also can file here. And India now maximum applications, 80% applications are by foreigners through PCT route. They file in their own country, within 12 months they file international application, then there is a procedure that within 30 months you can file here.
PCT has more bigger time than this earlier Paris Convention. As per Paris Convention, we have 12 months only, but PCT allows only almost 32 months.
No, it is 12 months, international application 12 months. Both are same, because patent cooperation treaty is also because of Paris Convention, within 12 months you have file. But patent cooperation treaty, your file is processed there, because you in patent, when you file international application, this is common testing of your invention for novelty, obviousness of this thing. So, they create a search report, or 18 months they publish also. Now, after going for a search report, if you think it is worthwhile to go to other country, because every country you have to file it, then it is called national phase. International application within 12 months, then national phase application within 30 months it is there, but India has given 1 month more time, 31 months. The purpose is there that when a person does an invention, number one, he files application. He himself may not be a entrepreneur. Then as soon as he files an application, he wants to sell the application, sell the invention now. So, he goes and searching, and he is still not sure whether it will be useful or not, whether it will be commercialized or not, whether somebody will be able to take it or not. But within 12 months he has to file application, complete way he will file, then let him file. But still within 12 months he are not sure what is to be done, because he is not able to sell it, he is not able to license it, nobody is taker. So, they said when you are going international level, so you are spending lot of money now. So, inventor may not be able to spend so much of money. They said, okay, you take more time. So, they said, okay, take 30-month time, you file complete file within 12 months, it is a must, but you take 18 months more. As soon as your application, after 18 months you publish in all PCT journal also. So, people will come to know your invention is there, they can come to you and purchase from you, okay, sell me the invention. So, 18-month publication, public will come to know, they said 12 months more is there, you can sell the invention. So, 30-month period is given only for the invention, so that you can commercialize it. But even then still, if you want to say still my potential is there, they say, okay, file national phase. Supposing you say come to know that my product will be selling in India and in Japan. So, you only file national phase application there in those countries, do not file. So, after 30 months you still have a choice, but you want to go for only these countries, 2 or 3 countries, but you do not want to go all the countries.
Sir, any provision to late phase after this time?
No, India do not have, Canada have, they have to, because you know this country, because our country says we cannot wait so long. If you want to file it application, still you have more time, because you know you have only protected, still you have not got the patent, but you have shown your interest that okay in India. So, 31 months they have given maximum time. If you do not enter into 31 months, your application lapses, it falls in open domain. So, I can continue. Hmm?
But basically,
Sure.
what is difference between patent attorney, patent agent, and patent examiner? Patent attorney and patent agent, maybe patent examiner.
Okay, I will explain. Patent attorney is just like advocate. Patent attorney is in fact all the is being taken by whosoever does a patent practice. He has to pass an exam in patent agent. A scientist, BSc person can pass the exam.
Patent agent he can pass.
Can. He is just like an advocate for patent office. And all specification also he can only pursue. That is the patent agent, and if he is advocate also, it is generally common term use patent attorney means he is patent agent and advocate. So you write in the claim that I claim a pen. Earlier it was a fountain pen, now my novelty is this one. So you will search for. So no need to write, but you have to write in specification everything, how it works, what is the best mode, what is the novelty. But when the examiner searches only claims, he searches, they will only search for ballpoint pen. And the examiners, they are the responsible person who gives you the patent. And patent the controller is the right authority. In fact, Controller General of Patent Office is the authority to grant you patent. He is assisted by
Yes,
assistant. There is a cadre I can tell you. इसको हाँ कर देंगे इसको. You can ask some questions also so that I can reply you. My purpose is there not to teach you what my purpose is कि you should know what you want to know.
Sir, suppose what are the career prospects in IPR?
IPR career perspective. Okay. In IPR patent examiner, you are a scientist, so immediately you can apply for a. Now 459 vacancies are there nowadays. You can apply there online. National Productive Council is there.
If already
But
we
if
are
you are
saying
already
no
employed,
purpose.
so in examiner no need to go there. You can go on deputation sometime.
So one of my younger brother is doing law.
Huh.
So after LLB, what are the career prospects of?
You know, if you want to go to patent, so there is no need of any law. It is scientist based in fact. If you learn law, it is additional advantage. But you have to do a practice. If you go for the patent examiner, it is just like a job you are doing. Then there is promotion, assistant controller. Then basically controller is a controller generally statutory authority of granting the patent, but he can sub-delegate. So what he has done, from examiner promotion goes to assistant controller, then deputy controller, then joint controller, then senior joint controller, and then controller general. So these are the cadres. So examiners, the lowest cadre, promotion to assistant controller. Generally, CG has given delegation to assistant controllers that you can grant patents. So they are called controllers now. Now one assistant controller will be coming to give you lecture. She is a controller. Controller means she grants the patent. What she does, examiner searches the reports, tells whether some technology already known or not, then puts up to a controller. Controller checks on this thing. If there is problem, they will ask the applicant, come here, have a hearing, raise the objection, remove the objection, amend the claims, and then grant the patent. So authority is the controller. What she is coming, she will grant the patent for her technologies. So they are a section in patent office. Technologies that biotech section is there, mechanical section there, computer section there. So for each there is head of, and there are number of controllers in each section. Similarly, there are 4 patent offices. In fact, I am going to discuss that one also because time 20 minutes. I will go a little bit more. So this patent cooperation, yes.
When we file international patent,
Hmm.
then they will ask if I want to file for say 5 countries.
Hmm.
So the time frame will be only that 30 months.
30 months, yes. 12 months. 12 months is there. You have to file international application, or there is a convention route also. You direct in 12 months you file in those countries. Under Paris Convention, you get a priority as if you have filed 12 months ago with the same country. This is only to protect, because in novelty is checked on particular date when you file, first disclose your invention, and it is published then within 18 months. So your priority date is fixed once you file in your own country. So you have enough time, 12 months, to go to other countries also. That is why the system is there, because it is an international one.
So what is that idea patenting?
Idea?
Ideas can be patented.
No.
Like pre-patent. Like
No, only method which comes to some vendible product or product. I will also give definition particularly. Now, Paris Convention, I will explain you. Paris Convention is priority right. It provides an application for one contracting shall be able to use its first filing date as the effective filing date in another country. Means you file in USA. So, within 12 months, if you can file here, it means you will get the priority. Your novelty check will be done from the 12 months ago. Okay. So, this is called a priority right. Within 12 months, all over the. So, this is very important provision because it helps you going internationally. Again, there is one more rule of independence is there in Paris Convention, that if one country assesses your invention, they may refuse the patent, but other country is also independent. They cannot take an example that because it has been refused there, it will refuse there. Though this rule of independence there, this is very important. Though patent office will ask for information that wherever you file, what is the status there. But on the basis that it has been refused there, they cannot refuse there. Similarly, if the patent they have been granted here, but they have to independently check there this thing. So, these two are very important provisions that generally USA grants so many patents, in India we do not get the patent. So, because they have to check. Yes, sure.
Sir, suppose today in India, sir, I have patent has been filed. India rejected. Internationally, I also have applied, sir. So
International which country?
Say USA I have done. USA, now the USA will accept it from the date of the day I have applied here, or it will take.
Here no relation. Application, priority check will date from the first filing.
First filing, suppose I have done on last year I have done it, sir. Within 12
I tell
months.
you, novelty check is from the supposing you filed in one application, first time when you file in any patent office of India, a world, and within 12 months you enter there. But this country will give when you 20 years from the date when you filed here, but your novelty check will be from the 12th ago.
Suppose 12 months
be an
back I have
invention
found
or
that
not?
date, that date will be counted, or I will be given a fresh look, like it will be the date they do the.
I tell you this, first of all you file your own country, domestic country, file. Here if you get a patent, you will get from that day to 20 years.
No, we are asking one thing, because in India that patent can abandon.
Okay, agreed, that is I coming to you.
European country will accept it as a new one?
Because your PCT application within 12 months you have filed there,
We have filed,
it means you have filed in European country also.
we have filed, that's.
But it means you have filed nothing to do with this thing. Rule of independence say like
It's a date from which the applicability. Now I was getting a benefit if India had accepted the date where the minority.
that is why I say rule of independence there. The testing of invention in India, there are different standards, testing of invention USA different standard, laws are different. 20% laws are different.
that patent date they will consider when we file it at the international level. That date was.
That date.
Not Indian date.
No. Indian date will be only for prior art purposes, novelty check, but date of patent will be for date of international application. You will get 20 years from date of international.
It means, for example, that particular transparent technology we have filed in India and 5 more countries, and they all countries are having different rule for their invention qualification. For example, in 3 countries the technology got passed. It means we can get patent there, not in
Yes, you are right. Because testing methods are different. 80% is same, novelty check, inventive step and utility is there. Now, take a method of treatments. Your claim has method of treatments. It is allowed in USA, not in India, not in Europe. Similarly, business methods, they were allowed in America, not in India. So, that is I had non-patentable subject matter is also there, even if invention is there. So, in that case what happens? You may get patent there, you may not get patent here.
And one more thing I will add here, for example, out of the 5 countries, one country has rejected that patent on the basis
Doesn't
of
matter.
on the basis of prior.
So if you convince, you can amend the claims, you can say this prior art part you remove from the claims and give novelty. So, amendment of claims you can very well get patent.
Because we have lost one patent.
There is no relation with this. That is why rule of independence. That is why I specifically in Paris Convention I say rule of independence there. Grant of patent in one country have no effect on other country. Refusal of patent in one country has no effect, because they have different checks, different standards. They have different laws matching to their society. But they ask information. If on prior art they have, you convince them, okay, I have amended the claim, now prior art supposing was there, so I have removed that part. Supposing, take an example, in claims you write,
Problem is claim only. If
that
you
is
don't
the
write
patent
it,
only do the same
it
thing.
can be
No, no, no. Patent or do the same thing. They narrow down the claims and they get the patent. This is not like after we are getting a patent, there is no problem in that one, because you convince them that whatever are there, so I have narrowed it down. Supposing, take an example, there was a patent, you use the word metal. Here you said, I am using aluminium only, because aluminium is robust also and this thing, but now metal covers also aluminium. So, it is a prior art. So, here you will not get a patent for metal, but if you narrow down, you write aluminium, you will get a patent. This is jugglery. For metal is a known prior art, means already known, but you say I am only getting my only for aluminium, so you will get a patent.
Sir, suppose I add to each question. Like suppose my patent is rejected in India and it is accepted in say USA. Then somebody can copy that part and make it in India.
In USA it is valid, in India it is not valid. If he sells in India,
it means whatever
open.
we disclose in India, it becomes open to India.
India. And similarly, if somebody, so many patents are filed in USA and they are not filing here, it is free to you. Use your technology, copy it, whatever you want to do it, nobody can stop you. That is why freedom to operate search is there. It is national based.
Can we send the product to USA?
If their patent is there, they will sell like royalty. I gave an example of rice. What it has no effect if they have got a patent there, but we are exporting. If they say the same species they are exporting, they say give the royalty. Infringement. Understand, this patent system is only filing system international, 80% laws are international, reciprocity is also there, so many things are there, but even then it is nationally granted.
The infringement of patent act is only the royalty or penalty or some other punishment also?
No, it is only royalty of this.
Only royalty.
There is no, in particular criminal liability is there, but you still not enforced anywhere, it is not there. Criminal liability is there, you don't work the patent and don't allow anybody else also, they can give you compulsory. You don't tell also, you block the invention, neither use yours nor use others. Then there are some provisions, that one. They give you notice to you, work it, give license, if you say, and they will revoke it. Or you give some false information for blocking it, then criminal activity may, but it is not there. In patent there is not. Okay. Any other questions?
During the patent filing, all the information means research information may be disclosed. And I claim 2 or 3, 4 claim. How to prevent the other claims if any person is stored in the...
No, it is open, but you don't claim, it is open to all. Wait, your legal rights are on there what you claim, and these claims will be tested for patentability, invention, novelty, obviousness and this thing. Rest everything which you have disclosed there, if you have not claimed, it is open to the public. That is why patents is working, because it is opening to everybody, you copy it. Whatever you don't want legal right, give others a chance to design around, do research over it, it gives a good platform. That is the use of patent system. In fact, I say benefit to researchers. On click a mouse, they will say no duplicator of research. I was given a lecture in very big company there. Their scientists were giving lecture there. They say, we file a patent after 3 years. They say, oh, already it has been patented. Okay, have you done prior art searches? Before you take any research project, go for a prior art searches. That I will just cover that one also. Now this I have already in TRIPS agreement, you will be already covering this one, but basically article 27 to 34 relate to patents, that patent term will be 20 years and main points are there. Patent shall be available for any invention, whether product or process, in all fields of technologies. So all fields of technology, provided they are new, involved and let's say. So, this is novelty, this is novel, new means novelty, in time invention means obviousness, non-obviousness and utility. So, this is all over the world, okay. But only thing is there, however member countries shall provide protection of plant variety, I have a patent. In plant variety, India is not having a patent system, they are having sui generis system, which is protection of plant variety and farmers' right. So, this is allowed also by TRIPS. So, our law is TRIPS compliant. Now, when you file a patent application, in fact, you have first of all to find key. When you do a research, what you find in research? You first identify problem in present technology. Make a prior art search, what is the problem in technology and what you want to cover the gap, what solution you are looking into. That is why you will go prepare search strategy. You search all over the data. If you now identified what is my problem, how I am going to find a solution, then see what is all over the world. You have prior art searches, search strategy, you find a keywords and then search strategy, search prior art of existing technology and then do the research. This is the basic principle, that otherwise it will duplication. Do you start doing research, somebody already had done it, and databases are very. Now, where to file the application? For Delhi, this is jurisdiction is there. For Delhi, you have, it is for state of Haryana, Himachal, Jammu, Kashmir, Rajasthan. If inventors relate to these cities, any one inventor, the first inventor you can file, or applicant belongs to this thing, they have to file in Delhi. Similarly, in state of Andhra Pradesh, they are resident of this thing, they have to file in Chennai, and rest of India is Calcutta. But if foreign country is there, outsider, they if they do not have a place of business in India, the address for service of patent attorney you can file there. If somebody from foreign country gives, I am a patent attorney, so gives to me file, so I will file in Delhi only. And once filed in one where it is not transferred from one to other, processed here only. Foreign filing, I have already explained you, file in India, I am talking within 12 months. If you want to file in some, get protection in somewhere, suppose you are exporting your product in one country, so you file there within 12 months. This is a convention route. Or PCT route is there, you within 12 months file international application within 12 months, it means you have filed in 100 some countries straightway. And then in PCT route, after 30 months from priority date, you have to file application straightway in those countries which you want to go. So, you get 30 month time. So, in convention you can straightway go to the country, other country. In PCT route you can go to for international application, and 30 month, India is 31 month, you can go to national phase. So, it is called national. So, you will be learning PCT system also. And if you want to file direct application outside, Indians cannot file outside till they get a foreign filing permission for invention. Within, or first file here, within 6 weeks you can file outside, or get a section 35 foreign filing permission if you want. There a problem comes, supposing one inventor is here, one in USA. Now, both have restrictions. In USA you cannot file outside, till 6 months you are filed in here, you cannot file outside. So, if both inventors are there, so they cannot file. So, in that case one has to take a foreign filing license. Suppose you want to file in America, so American inventor will not get a need permission, but Indian inventor will need a permission. Indian inventor means resident in India.
Indian inventor from whom he has to take the permission, sir?
Patent office.
Patent office.
There is form 25, want this permission, you apply, within 21 days it comes here, there is no problem.
Sir, one more, sir, in convention route, sir, where to file, sir?
Convention route, in which country? Supposing if USA you have filed for one, within 12 you want to enter India, file in India. If you are Indian, first application you file in India, you want to file in either Europe, or you want to file in, supposing Japan, file in Japan patent office. When you enter national phase, the patent agent or patent attorney of that country comes into picture. Okay. Now, I was, because all Indian topics will be discussed, so I was in international, what is the European Patent Office? So, I will quickly go through this thing. Time is there, but I will try to go within 5 minutes. This European Patent, why I am saying, in India only one country is there. In European Patent Office, there are 38 countries. So, European Patent Office, for all those countries, you file one application in European application in European Patent Office, and you designate 38 countries straightway. So, I am just giving you a little bit quickly VPO that European Patent Convention, it was signed in 1973, implemented in 1977, and they have this EPC convention has their tax preamble, article, implement extension, and under this there is European Patent Organization, and under this there is European Patent Office, which does all the work of patent granting and searching. In fact, USPTO, US State and EPO are very strong. They have I am taking this one because our Indian laws basically parallel to this one, 90% are same, and they have the biggest databases. Quickly I will go through. Enables applicant to seek protection of 38 European countries. EP also provides information, training and services. In fact, they give a training, the EP Academy there, you can see also, you can get a material. Even if you are a teacher, they have special kits for teachers also. 1980 January, EPO granted first patent. They started first patent. This patent grant means for 38 countries it is valid, and you have to validate it by publishing in each country then. In 19, and you just see quantum of in they granted first patent 1980. In 1986, within 6 years, they 1 lakh patent. Then in 1991, it was 2 lakh patent they issued. When in India, hardly per annum, I think 3,000 and 4,000 maximum patents are issued. In 1983, European Patent Office, Japan Patent, they laid a groundwork for harmonization of patent system and practices, and they started a back-on project, that back file conversion. So, all the data which was on hard file, they scanned all the data and then posted in the patent office site. So, you can see the, and now all the data is digitalized. You can still click of a mouse, you can search. The EPO, JPO started scanning and converting 41.6 million patents from paper to digital form. And EPO International Patent Document, EPA-DOC holds more than 90% of all patent documents published around the world. So, it is free.
Sir, in EPO that we slate,
Huh?
when we are entering any of the word, for example, in the fisheries
Huh?
sector, for example, in the fisheries sector, I want to do some fire art and I want some data.
Hmm.
We are putting one word and they will show 5,000 or 6,000 details are there, but they will show only 500. So how we can go more than 500?
This is patent strategy. You know how you select the keyword. So, in fact, when you are from TIFIC, somebody is how to make a search strategy. Search strategy is very important. In fact, in the beginning I gave you, you have to choose the right keyword and you narrow it down. Then there is strategy. First of all, then you have to go for title wise. Then you have to go abstract wise. So, there is search strategy. You can do it that because everything you can get from there. Because
They are showing, they are giving details and all, but they will not give more than 500 details. For example, I find the 6,000 patents, but they will show only 5.
no, you have to go to next page. This is not like
I
that.
went through that.
No, it is not like this. You know, if your keyword is okay, even if you go to PCT Gazette also, they will tell okay how many documents have come. 5,000 documents and 125 on one page, you can select 50 on one page, then go for the title search. So, but even then search there, it is not like very fast. I tell you, it is so wonderful. Even Google Pay.
It is there. I done a lot. If you can get, please suggest us.
Search will get. I do myself. Searches I also might do self. We get 5,000 page straight away. We search PCT Gazette, USPTO, EPO is one of the most powerful. And they get even, you can get data also, files also.
I request for 5 minutes after this lecture.
No, you will get prior search will be there, topic will be there, you can see, there is no problem at all. eSpaceNet is there, particular for this thing. It was 1998, this search engine, all the databases are there. It is one of most powerful databases, it is a free. and it is user friendly, and there are so many search parameters. In 2000 they started a translation service also, because European Union have main problem, European Patent Office, that all countries have different languages, Spanish, French, German, English. So now, and they have made your databases, machine transfer for Japanese, Chinese, you can get in English straight away. So it is very powerful. That is why I have specifically eSpaceNet, I have brought it there in 2000 machine language, and now in future all 38 member state and Chinese application, they will also come in databases there. So you can get a research, but only you have to make a, if 5,000 patents come, you can't work on this one. So how to narrow it down? Our patent office does the same thing. They also search and give you, okay, this is a prior art, and raise the objection. Okay, now Patent Academy is there. So I think and then in EPC, this is the patent. In fact, this is section 21J. This is what is the patentability test. They are new, involved and inventive step in all field of technologies. This was the amendment made, and these are the not patentable invention in 52(2). So these are the some non patentable inventions. I am not going to discuss much, because next. Similarly, patent. So Indian patent law is and European almost similar. In fact, they say method of treatment is not allowed. They are not invention. Plant or animal variety is essentially for the production of MI. This provision shall not apply to microprocesses of the MI. So these are the not patentable invention. Now type of patent application I have already discussed. Now ordinary application means you file in India. Convention means within 12 months file in other country. International means within 12 months file in PC route. Then national phase application in India 31 month or 30 month anywhere. Application patent of addition is there. Supposing in one application there are 2 inventions, they allow you to divide application, make 2 applications. So it is a divisional application. Now this part will be, specification part will be taken care of by this. I think, any question?